Okay, so finally we're going to look at positive action and disability, and we're also going to talk about the rules on pregnancy. So first of all, as I've said before, positive discrimination in the UK is not allowed except in a very small, constrained number of cases. The Equality Act 2010, Section 158, enables employers to do positive action measures voluntarily. So they're not required to, but if employers want to correct disadvantage based on a protected characteristic, they can take measures or they can adopt measures which are proportionate to achieving that legitimate aim, correcting disadvantage. But what they're not allowed to do is that they're not allowed to set quotas or hire people who are less qualified than others based on a protected characteristic. What you can do is you can have what we call a tie-break case. If you've got a workforce where women are underrepresented, and there are a group of applicants, and you've got some women who are equally qualified to men, you can say that the women who are equally qualified can be hired over the men in order to correct the disparity in the workforce. But you can't do it if women are less qualified than the men are. So you can only have it in a tie-break case. In Re Bardek's application, the Court of Justice sets out what are legitimate positive action measures. So this was about Bardek bringing judicial review against a law in the state of Hessen, which enabled positive action for public office. And the Court of Justice very helpfully outlines what is lawful and what is not. So if you want, as an employer, to give priority to underrepresented groups with equal qualifications, that's the tie-break situation, then that is lawful. You can also have binding targets for women or underrepresented groups in temporary posts. You can have targets for training. For instance, if you want to give more training places to underrepresented groups, that's fine. But what you can't do is give the actual job if people are less qualified. And you can give people with equal qualifications guarantees that those satisfying conditions at least get to the interview stage. And fifthly, when we're looking at the composition of employees' representative bodies or administrative or supervisory bodies, you can have quotas which are positive discrimination or affirmative action, because the rationale is that one of the jobs of representation is to actually represent the society, the community, or the workforce around us. So basically what that means, if we look at companies, is that we can have quotas if we want to for women on boards of directors, or we could also have ethnicity quotas, but we can't do it for other jobs which are non-representative. Section 78 of the Equality Act is very useful in requiring disclosure of the pay gap figures. So for all workplaces with more than 250 employees, gender pay gap details have to be published. The manifesto from the Labour Party promises to extend this to the race pay gap as well. And there are still big differences between men and women on boards of directors. 44% of directors in UK FTSE 100 companies are women, but when we look at who the executives are and who the CEOs are, it drops down to 22% and 9%. And things are pretty similar and even a little bit worse for the FTSE 350 companies. The EU has a positive set of targets, which is some way behind where the UK currently is, so they wouldn't have much impact. But it says that at least 33% of directors have to be women, 40% of non-executive directors, or I should say, it doesn't phrase the law in terms of women and men. It talks about the underrepresented sex. If we go over to America, where positive discrimination is allowed, it's useful to look at what has been happening, but also what is probably due to be overturned or likely to be overturned by the current composition on the US Supreme Court. So in the United Steelworkers of America case and Weber, it was held that affirmative action is lawful to correct historical disadvantage. And this was about a collective agreement signed with the United Steelworkers of America that guaranteed 50% of trading places for black workers until such time as the number of black workers in the workforce reflected the number of black people in the local workforce. So to ensure that the workplace looked like the community in which they lived. And the US Supreme Court went a bit further in Johnson and the Transportation Agency, holding that women could be hired to a job even if they were less qualified than a man. And this was in a case where no women currently worked in a workplace where the work was as a road dispatcher. But in 2023, the US Supreme Court held, not in an employment case, but in a university case, that affirmative action for students to get into universities violated the Equal Protection Clause in the 14th Amendment. And so that is a very strong indication that the US Supreme Court, as currently composed, is likely to tear up the affirmative action provisions. Next is pregnancy.